So, as I previewed, very pleased to have Bethan Harris here this afternoon. So, it's kind of eminent housing lawyer and has been involved with a whole range of kind of housing-related court cases, which have kind of created precedents. And Bethan's been through the new DFG guidance and has got some other thoughts as well from her experience. So, I'll hand over to Bethan to talk you through some of her thoughts on the new guidance and the DFG rules and regulations.
Thank you very much, Paul, for that introduction, and thanks very much for inviting me to speak this afternoon. And I'm very aware of speaking to a very experienced audience, so I hope that what I have to say is of some interest. Anyway, speaking from a lawyer's perspective, I've got a brief introduction to my talk on my first slide, which I think Paul is in control of. So my second slide in that case, thank you very much. And this is just to explain the sorts of things that come up for a lawyer who might get involved with a DFG and adaptations, disability adaptations. This can arise in the context of a housing dispute or where somebody has a wider range of social care needs. And the types of things that come up we look at from the perspective of public law and whether the decision making in relation to the grant application or around the disability adaptation is valid in public law terms, and ultimately the remedy is an application for judicial review. And the sorts of decisions that we would be examining are, I've made a list of them there, whether the local authority has made a valid decision in rejecting a contention that there's a need for a certain adaptation. Say, for example, a mother saying that there's a need for toughened glass on the upper floor of the dwelling because of the behavioural issues of her child, the local authority not having accepted that, we would be looking at whether the decision making is valid in public law terms. Another example is a decision about the type of works that should be done. For example, whether the adaptation could be adequately done, and the decision making around putting in one sort of adaptation, possibly, for example, something that's less durable than another type of adaptation, maybe building, for example, a shower room as opposed to using installation of some kind of temporary unit, whether the decision making around that sort of decision is valid and takes everything into account as it should be, or whether there's been some misunderstanding as to the facts or some failure to look at the full facts of the case or to bring in relevant expertise. Those are the sorts of issues that can sound in public law principles. Unreasonable delay, that can be so unreasonable as to be unlawful. Disputes as to the correct interpretation of the legislation. Paul referred to the 2020 Islington case, which was to do with the interpretation of one of the limbs in section 23 of the 1996 Act. That's an example. And then we have issues around the overlap between the obligation to fund a DFG and the obligation to meet needs under the Care Act, and when needs under the Care Act can be adequately responded to by referral off to apply for a DFG. Sometimes that's appropriate, but not always. Thank you very much. So I'm going to just race through this a bit because Paul has already covered it, but I just wanted to set out at the outset the key parts of the legislation on eligibility, because I'm just going to look then briefly at the guidance that relates specifically to eligibility, because that's the bit that I come across in practice. So the gateway provisions are the purposes as set out by Paul, all the different purposes for which a DFG must be approved subject to the other provisions in the legislation. So that's part one of the decision making. And then part two is it necessary and appropriate to meet the needs of the disabled occupant, for which the social services authority must be consulted? And then the second limb to part two is it reasonable and practicable? Okay, and on to the next slide, please. Thank you. So the guidance, and we're going to look at whether the guidance helps in those areas, is bringing together existing policy frameworks. It doesn't change policy, but it does make recommended best practice. And it sets out the law as understood by the relevant government departments. So it's not the definitive statement of the law. And it applies equally across all tenures, including council housing. Next slide, please. So I'm going to deal first of all with the issue about the overlap with eligible social care needs. Does the guidance help us on that with regards to clarity around that issue? So just as kind of mild criticism of the guidance here, it's not as clear as it might have been, I think, on this issue, but it does actually get the main points in there at 2.26. So basically the need that underlies the need for a DFG may also be an eligible social care need. And excuse the typo there, I've put Chronically Sick and Disabled Persons Act 2017, that should be 1970. Sorry about that, if you could just make that correction in your mind. The second point is, if the social care need in a given case requires to be met by an adaptation, and that can't be adequately provided for by a DFG, then the Social Services Authority remains under a duty to assist and can, of course, provide an adaptation. So those are perhaps the two key points. Then I've also at the bottom there, I've noted the point, obviously an important one, the fact that a person doesn't have an assessed eligible need under social care legislation, of course, doesn't mean that they can't be eligible for a DFG. They should still be assessed for a DFG because, of course, they're different tests. So what does the guidance say about the gateway provisions? Does it help us with our understanding of those provisions? Well, again, just mild criticism, and there aren't many mild criticisms of this guidance at all, but in Appendix B, it says that this part of the guidance sets out the legislation, but it doesn't actually set out the legislation. It paraphrases the legislation. So if you need to know what the actual solid, concrete terms of the legislation are, you need to look at the legislation itself. And that's something you need to bear in mind. But having said that, it's useful in that it explains what is the actual meaning now as interpreted by case law of making the dwelling safe, which is on one of the lists of purposes. That is a relative concept. The adaptation does not need to be able to make the dwelling completely safe. If that was a requirement, then very, very few adaptations would fall within that category. The adaptation concerned would need to make the dwelling safer. And of course, that area is very relevant for people with challenging behaviour. And one of the strengths of this guidance, I think, is that it really does highlight how DFGs can be used and adaptations generally can be relevant for people who have conditions which cause them to have challenging behaviour. One of the points that I thought was really useful actually in this bit of the guidance is that when talking about challenging behaviour, it refers to occasional challenging behaviour referred to as behaving in a boisterous manner, damaging the dwelling. So it's not making the threshold too high there as to the sort of thing that could make it appropriate for there to be an adaptation to make the property safer, which is obviously a very good thing. So moving on to relevant and whether relevant works are necessary and appropriate to meet the needs of the disabled occupant. So this is stage 2. And within stage 2, there are 2 stages. In terms of how the guidance deals with this. And this is actually a really useful part of the guidance because it identifies that what this requires, this part of the legislation, is essentially an assessment. And then it really goes to town on saying what the components of that assessment need to be. It's an assessment, and also the second part of it is a decision about the appropriate adaptation. So there are 2 stages within this stage 2. So first of all, with regards to the process of assessment that's involved here, we have some very useful guidance around needing to bring in the right expertise into the assessment. And basically the right professionals need to be involved, which might be, for example, paediatric occupational therapists, and obviously occupational therapists and technical officers. And the guidance is very clear that the assessment needs to be person-centered. And of course, that's a very helpful recommendation. And with regards to disabled children, the guidance is clear that the assessment needs to take into account the parent's view, developmental needs, and the whole family needs. And again, we have highlighting issues relating to behaviour that challenges. In those sorts of cases, and this must be right, because obviously these sorts of assessments really require very nuanced sorts of decision making. The families and the carers need to be what's termed highly involved in the assessment discussion. And then we have further useful guidance, which I've highlighted there, about the aims of the DFG and the importance of identifying the experience of the client and the carer, and easing the burden on the carer and looking to anticipate future needs. So the next stage is identifying the work that needs to be done. And the approach here, again, in the guidance, very helpfully, is the personalised approach. You see there at point 1. And point 2, Paul has already mentioned this, the 9 guiding principles, which really are so helpful. There's so much in there that's good. The need for choice, the need for light, the need for space, the need to look at the family as a whole, etc. So staying with the part of the decision making which concerns identifying the most appropriate adaptation to be done, here again there is welcome guidance on the need to take into account of future needs. So the aim being, where possible, I'd say, to look to being able to meet not just current needs, but also anticipated needs of the disabled person. But of course, as I've commented there, that shouldn't be a limiting factor, because there'd be some adaptations that are not going to be able to meet future needs, but that wouldn't be a reason not to put the adaptation in. It's an aspiration more than a limitation factor. The legislation wouldn't warrant refusing an adaptation on the basis that it wasn't, for example, going to meet needs further down the line when the person's condition inevitably deteriorates. And then the point at number 4 is that I've noted there that further on in the guidance, if we go to Appendix B, we have a slightly different tone, and where we have a reference to that the authority would usually choose the lower cost option in order to achieve best value. Well, obviously, if that was the only principle, then it would negate, all the personalized decision making and the need for dignity and all the other things, and it would sort of drive us to just looking at safety and functionality. But that's clearly not what this guidance is trying to get people to do. So I think that has to be read in context. It's an option is not an option for consideration unless it is in line with the best practice that is set out in this guidance, and is an option that's been come to as a result of the 9-point principle decision making. And only then can the options be decided on in terms of which is the best value in terms of cost. That's my interpretation of this guidance, and the only way I think you can make sense of it. So what does the guidance say about reasonable and practicable? And this was mentioned by Paul, who quite rightly said that in light of the decision in the McEwen case, it's clear that this is a very narrow basis upon which an adaptation might conceivably be refused in some cases, and it's only where the condition of the dwelling itself is in a very bad state, a state of disrepair, or very old, so that it's not a sensible proposition to make the adaptation in question, but it doesn't allow adaptation to be refused on the basis that the local authority takes a holistic view of matters, decides that it doesn't think that it's a long-term proposition for a person because of their needs to live in this dwelling, as happened in the Islington case, and for that reason to refuse an adaptation. So this is a very narrow provision for refusing a grant application. So I'm moving now to the next heading, and this is, as I noted at the start, this is one of the things that comes up, and I'm going to be quite quick with the last few points. The urgency and the matter of delay, does the guidance help on this? And I'd say, yes, it does. It's got some very useful timeframes built in, and it's telling local authorities that this practice, best practice, needs to be met in 95% of cases. It's got timeframes for urgent and simple cases of 11 weeks. It's also identifies certain scenarios which are urgent, like coming out of hospital and being at risk. That's very helpful to flag that up, and others there noted at paragraph 2. And it also flags up the use potentially of discretionary housing assistance in order to deal with urgency. And I'm going to go to that now. We could kind of go to this. So I'm going to skim over this. This is just highlighting some other useful bits and pieces in the guidance, but I'll go straight to the next slide, please. Thank you very much. And this is to do with not DFGs, but the RRO, which is also covered by the new guidance. And the RRO is actually not something I come across a lot in my practice, and that's because it's discretionary. So it's not very often that it can give rise to a legal challenge. But clearly it has tremendous scope to fill gaps and to do things that are, potentially not very easy to do with a DFG. So basically, it's an incredibly broad power under this order, regulatory reform order, power to the local authorities to provide assistance in any form to any person for various housing purposes, including adaptations. The local authority must have a policy, and the chapter is on developing a local housing assistance policy. So just a few words about what it says about policies. These policies allow for the government funding, which is available for DFGs, can also be used for this discretionary purpose, and in this pot can be used more flexibly. And there are a whole load of examples in the guidance of that sort of the use of that sort of flexibility. The main theme is urgency. It's dealing with things that come up frequently, that might be quite straightforward, and that where a gap needs to be plugged very quickly in order to enable somebody generally to be discharged from hospital, to remain in their home, or their palliative care case, and similar sorts of scenarios. So again, very useful guidance. So on the whole, I think the guidance is great. I can look at cases that I've been involved in and think, if we had this guidance, we probably wouldn't have needed to have gone on so long. We could have resolved things much more quickly. So thanks very much to the authors of the guidance.
Thank you, Bethan. That's much appreciated. I suppose kind of referring back to, in fact, it's one of the questions, and I think your kind of view on the kind of McEwen and Islington case would be really helpful. So part of it was that you should look at each individual purpose on its own merits, which I think is relatively straightforward in its own. But then I suppose one of the thoughts that we've had and we've discussed on previous webinars is whether that means that you could put in separate applications based on different purposes and have multiple applications running at the same time, which I thought it's probably difficult to not approve them because you're only looking at each purpose separately. But whether that was what the judge intended when he set out his judgment on that case, I'm not sure, because Islington didn't really make that argument. So what's your thoughts on perhaps making multiple applications on different purposes?
Well, I mean, that's a really good question, and I would really, I have to hesitate in giving any sort of definitive view on it. I mean, as a lawyer who represents tenants, I would tend to say yes, of course you can do that. And my honest view is that I can't see any reason why you can't do that, because obviously there were other issues in relation to this particular property in the McEwen case, which could have given rise to a separate application in order for those to be resolved. But yeah, I mean, I have to say, I just can't see any reason why you can't do it. I think that's there for someone to find a reason why you can't, really.
Yes, yeah, I felt that, and I've spoke to other people who said that as that kind of argument wasn't specifically made, you couldn't necessarily draw that conclusion. But I don't see how you probably couldn't, but or how you would not approve a grant if they were based on separate purposes.
Yeah.
And somebody asks, has said that we can't use two grants at the same time, but I suppose, as we've just said, that there's no reason why you can't make multiple grant applications. Although I suppose on the flip side of that is there are occasions maybe where there's two disabled people in the same property, and there may be more kind of an application from each.
Yeah.
But I think my view is that that's probably one of the cases where you would use your discretion under a housing assistance policy to do one larger application rather than having the complication of doing two standard DFG applications.
Yes. Yeah. I mean, I can see the comments that are coming through from our, our very experienced audience, and about joint applications, about the financial limit, obviously, on grant money. Yeah, I mean, I can't give a definitive answer on this, but I think one should always start from the premise that if you tick the boxes of the process as you go along, then, and you get to the end of it and nothing has said no, then you run with it until somebody finds some reason why that can't happen.
Yeah. Yes. I think it would have been really interesting if Islington had raised the issue of the maximum grant. Now that applies to the different purposes, but obviously they never did. So so I guess we're waiting for the next court case to help us out with that one.